The keynote session titled The Light Beyond the Horizon Understanding the Diverse Dimensions of ADR was a captivating start to the event. Justice Sikri delivered an enlightening address that delved deep into the multifaceted world of the alternative dispute resolution.
Distinguished guests, ladies and gentlemen, we're going to move on to the first session of our event, the keynote session, titled The Light Beyond the Horizon, Understanding the Diverse Dimension of ADR. With that, I'd like to call upon the Honorable Justice Arjan Kumar Sikri to come up on stage and deliver his speech.
Good morning to all of you who are present here. Professor Dato, Dr. Ahmad bin Mohammed, Chairperson of AIAC, Dr. Sundar Raju, Director, in absentia, the Deputy Law Minister Ram Kirpal, and I'm sorry I forgotten your name, but all other distinguished judges, lawyers, practitioners, and students. It is indeed a pleasure for me to be here and delivering this lecture, for which I thank Dr. Raju for inviting me. As the topic suggests, which may be a part of the theme of the conference itself, that is PRISM, the spectrum of ADR. And I'm here to speak on, as it suggests, the light beyond the horizon, understanding the diverse dimensions of ADR. Just before that, let me tell you two things. Number one, as Dr. Raju told in his introductory remarks, we know each other for almost 20 years now. And I was the judge in the High Court at that time, and I had become his admirer for what he was doing for KLRC and the way he ensured that KLRC actually shines in this horizon insofar as arbitration is concerned. And I have seen now what he is doing for AIAC, of course, under the guidance of our Professor bin Mohammed, who is the chairperson. And secondly, that this event, which is the 5th edition of Asia ADR Week, which has been organized, and the manner in which it has been organized, I must commend him and his team for that. Coming to the topic, so the theme of the session is not just interesting, but also emerging. It is interesting as it affords a chance to explore the various dimensions of alternate dispute resolution, which is commonly called as, known as ADR. It is emerging as it is continuously evolving with a lot of churning that is taking place at international level about the adoption of new technologies and combination of ADR methods, to which I would advert to later. The scenario that is emerging reminds me of the great linguist G.H. Lewis, who had once remarked that the emergent is unlike its components insofar as these are incommensurable, and it cannot be reduced to their sum and differences. But before delving into the discussion on ADR, let us first understand as to why disputes occur in society. That is what I saw in the brochure of your this event also. Generally, a conflict arises when two or more persons seek to possess the same object, occupy the same space, or same exclusive position and play incompatible roles or undertake mutually incompatible means for achieving their purposes. So, on a realistic note, we cannot say that the society will be fully free from conflicts or disputes, as it is the byproduct of communication between people. However, we can aim at its early resolution, and the same is needed for the progress of the human race and for peace in the society. The sooner a dispute is resolved, the better it is for the parties concerned, in particular, and the society in general. Whenever we think about resolution of disputes, the first thing which comes in our mind is the notion of lawyers arguing the case of the parties for adjudication before a court of law. Also, the adversarial method of justice delivery is followed, which has been normal system for resolving disputes. But emergence of ADR, which has now traversed to, instead of alternate dispute, I would say amicable dispute resolution, sorry, shows that courts are not the only medium of resolving disputes. ADR is the focus of growing interest in international business world. And Stephen Covey, in his book, he calls it as the third alternative. The third alternative thinking has revolutionized the practice of law, as it leads to participatory process where parties have the autonomy to craft holistic solutions to their problems. The word alternate in ADR signifies the avoidance of those methods of dispute resolution which flatten the subtleties of complex human behavior into simplified legal tests with binary win/loss outcomes. ADR has permitted greater procedural flexibility and the possibility of generating creative solution to the complex problems. ADR not only aims to restore preserve the dynamics of the contract in the context of commercial disputes, but also encourages the resumption of dialogues between the parties, which is why ADR has become the de facto choice of the parties for resolving commercial disputes. This was aptly highlighted by a great Indian judge. Many of you may have heard his name, Justice V.R. Krishna Iyer, who in his eloquent statement said, and I quote, "Commercial causes we may observe in prolegomena fashion should as far as possible be adjusted by non-litigative mechanism of disputes resolution, since forensic process, dilatory and contentious, hamper the flow of trade and harm both sides, whoever wins or loses the less." In this spirit, my objective in present address is to explore how various methods of ADR are continuously emerging in the present time. To facilitate this analysis, I have divided my address in 4 parts. I will initiate my discussion in part 1 by emphasizing upon the transnational commercial disputes in the age of globalism and now what we call a recent phenomena of anti-globalism as well, including pandemic which we saw, which created havoc in the world for 2 years. This will give me the background to trace the history of arbitral process as an anatomy of lex mercatoria, and then discuss the future of transnational arbitration in a globalized world, which is the new term that is coined, and thanks to what is happening in Asia, including in Malaysia. However, there is a flip side too of this rule-based order. Over the last decade, there have been growing wave of discontent with various aspects of arbitral process, particularly in bilateral investment disputes, to which I would specifically advert to. In part 2, my endeavor is to explore some of these concerns with specific emphasis upon apprehensions revolving around the polymorphous decision-making process in investor-state arbitrations, as I said just now, and highlight the allure of mediation in resolving bilateral investment treaty disputes. In fact, as Justice Clear L. Dewey of Canadian Supreme Court had famously remarked that in this polyphonic world, it is important to acknowledge the value of all potential sources of new materials, new melodies. When it comes to international commercial dispute resolution, mediation is that source of new melody. Part 3 of this address will tend to eulogize the power and qualities of mediation as an ADR, simpliciter, and how mediation in various forms, which is again a continuous development, and that is MEDAB, ARMED or ARMEDAB, and I will allude to that. Part 4 thereafter, time permitting, otherwise I have given my essay to the organizers here. So the new elements which are creeping in the ADR process, to which the speakers at the inaugural session had also alluded to, that is artificial intelligence and technology, which is giving rise to other forms of disputes as well, and one of them is online dispute resolution. And so with this, let me first come to the first part, transnational commercial dispute in age of globalism. Since the early 19th century, globalization has been significant transformative force, bringing about an interconnected world defined by massively increased advantages and business to reap economics of the scale across the border. As cross-border trade has flourished, so inevitable has the propensity for disputes to arise. By providing the mechanism for the resolution of cross-border commercial disputes quickly and fairly at proportionate cost, law has aided in creation of the conditions necessary for engaging in cross-border commercial activity. This is only possible because law has served as global, as I call it, currency of trust. With globalism and various methods of international commercial disputes resolution developing hand in hand, with the latter supporting and facilitating the former. Globalization has created a new transnational marketplace, and this has witnessed a proliferation of commercial relationship with counterparties one might really know, fully understand, or even trust. Thus, dealing in the global marketplace calls for a more arm's length regulatory framework or the rule-based system, requiring the law to play a crucial one. We can see this at all levels of economy. In business, legal contracts have supplanted the exchange of memos as the primary means of economic command and control. Between nations, the international law of obligation has also lent structure and given order to international trade. The UN Convention on Contracts for International Sale of Goods, the WTO's General Agreement on Trade and Tariff, that is GATT, are two well-known examples. If the legal rights can now be considered as new currency of trust, as I said, then it follows that our legal framework have become the notional bank in which we can safeguard and realize those rights. Among the clearest illustrations of this are the methods for transnational commercial disputes resolution that have evolved dramatically in recent decades, leveraging on the advantages of international enforceability, neutrality, and procedural flexibility. Arbitration has emerged as the preeminent means of resolving transnational commercial disputes. And how arbitration process as an anatomy of what we call lex mercatoria evolved over time is well known. The concept of lex mercatoria reflects the new relationship between the international business and trading bodies is governed by the body of transnational laws. The new system of law overseeing commercial transactions and overseen by private judges for commercial class came to be known as lex mercatoria or law merchant. Conflicts were arbitrated by the members of the merchant class itself. Arbitration, like the lex mercatoria, was outside the nation's court system and amounted to self-regulation by the merchant elite. And it is this concept which has given rise to, if I may call, international commercial arbitration regime. In this perspective, some scholars have claimed that arbitration is a universal institution which has no boundaries of time and space. This has led to the formation of international law principles on arbitration. This entire new jurisprudence over in last 50 or 100 years, which has been created on how international disputes have to be resolved. And what are the various, I would say in brief, some of the features which have developed and across the world which have been accepted by virtually all international arbitral institutions, including AIAC, and I'm sure that in 2023 rules which have been released today itself, they contain all these features because these have become universal features. First is party autonomy, as that is the bedrock of any arbitration, that the parties have absolute freedom to determine the conditions by which the arbitration agreement will be governed. They have freedom to choose the arbitrators, seat and venue of arbitration, and also curial law and substantive law. Let me tell you here very interesting development which has taken place in India in this behalf, and that too by the Supreme Court of India in two very landmark judgments which was given in 2022 only. First is that insofar now we know that there's and that's a need, and that is why that provision is there in almost all arbitration, international arbitration institution, including AIAC, is about the emergency arbitrations. In Indian law, that is in Indian Arbitration and Conciliation Act, there is no provision for recognizing the awards given by the, or enforcement of the awards given by the emergency arbitrators. In 2019, there were certain amendments. The Law Commission of India had recommended inclusion of this provision, but which was not done somehow by the legislature. Notwithstanding that, in a recent judgment, as I said, in 2020, in Amazon Investment Holding versus Future Retail, the Indian Supreme Court said that going by international practices, we have to recognize and we will enforce the emergency arbitration also. Second thing which is very interesting and should be music to the ears of persons like Dr. Raju or AIAC. Normally in international law, yes, we have, as I said, that party autonomy, where the parties choose their seat of arbitration. It may be, suppose, a dispute between the Indian party and Singapore party, they may choose Malaysia, AIAC, as a neutral venue. But party autonomy concept has been expanded to this level by Indian Supreme Court, where they have said that even two Indians, and they're in a way it's like domestic arbitration, they're two Indian parties, if they are litigating and if they want to choose AIAC, they are permitted to do so. So this going in arbitration, you want to settle the dispute, it is your choice as far as Indian law is concerned today. Go to any jurisdiction anywhere in the world, and the award given by that particular organization or the seat of arbitration will be recognized in India. So that is a very, very, I would say, landmark development insofar as the concept of party autonomy is concerned. Then second thing which everybody knows, and that was necessary, was that if the international arbitration, as I gave the example between India and Singapore, say we come to Malaysia, suppose award is given by Indian against the Indian party, so it has to come to India for enforcement. So it took place this the question that how these should be enforced, and we know it. What happened first, Geneva Convention and then New York Convention, to which now New York Convention which prevails mostly, and almost 200 countries are signatory to this convention. So this has facilitated and not only the recognition and enforcement of the awards, but in the process, it has given boost or fillip to international commercial arbitrations. Third thing, which phenomena which occurred was, I would say, convergence of laws when we come to international arbitrations. That is, having the laws which should be uniform in nature. As we know, apart from New York Convention, etc., which I said, now we know UNCITRAL has been coming out with model laws. It is this model law on arbitration on the basis of which most of the countries pass their laws. This becomes very, very important for one reason, that when we talk of the arbitration award given in one jurisdiction to be enforced in other jurisdiction, and many times the local laws, domestic laws of different countries would be of different nature. So therefore, the convergence, apart from the New York Convention only says as if you're signatory, yes, award of that country would be enforceable in another country which is signatory to that. So again, giving example of India or maybe Malaysia. So award may be enforced, but when it comes for enforcement, then under our Arbitration Act, it is that on what grounds it can be challenged and how it can be enforced. So the grounds on which it should be challenged or can be challenged, there should be uniformity. So that is where the model law becomes so important. And when it is, almost same provisions throughout the world, then it becomes easy for recognition and enforcement, and even for the purpose of conducting the arbitration proceedings. So that is convergence of laws, and it did not take place only in respect of passing the laws, but some of the fundamental principles which are again universally applicable and are accepted have been incorporated in these laws. And if I give an example, competence, this principle, that first it is the tribunal, if jurisdiction is challenged, to decide on its jurisdiction, and only thereafter it can be taken to the court, is universally recognized. And so then the principles on the limited remedies against the verdict, that it should be challenged on very, very limited ground. Confidentiality and transparency in arbitration, again universally accepted. Third party funding, on which there is a lot of debate now, and legal principles for interpretation of commercial contracts. Again, these contracts, how these should be interpreted, and on that basis only the arbitral tribunal will give an award. So that it has created its own jurisprudence insofar as the interpretative rules or principles are concerned. And this has, I would term is a totally different and a unique feature, which is the arbitral legal order or the transnational arbitration which has been developed. Another thing is that although I alluded to it earlier, but it has become necessary, is the one ground on which the award can be challenged in any jurisdiction is if it is opposed to the public policy. Now, the concept of public policy again, because public policy may be different in different countries, and as in English case it was aptly remarked, it is a very unruly horse, and when once you get astride it, you never know where it will carry you. So therefore, how public policy in different countries, different interpretation is given, and many times the awards are interdicted on the ground that they are opposed to our public policy. But here again, maybe taking lead from the UNCITRAL model, and like in India also, and it has happened everywhere, I think in Malaysian Arbitration Act also, that okay, we will have our own policy insofar as domestic laws or domestic arbitration is concerned. But when it comes to international arbitration, and if the international award is to be enforced, then we will go by what we call international public policy, where it would be on very, very limited grounds, particularly mainly these, that if it is the award is obtained through fraud, or if it is opposed to principles of natural justice, etc. Then Another thing which has, which I noticed the feature in ADR system or in arbitration is that there are specialized arbitrations which are, creating their own sphere or their own world. We have construction arbitration, we have in space, shipping, maritime, and BIT, to which I mentioned. And recently, in recent time, another thing which is emerging is blockchain disputes and the financing disputes, etc. So for that, again, there are now societies or there are institutions which take care of the special rules, like when it comes to construction arbitrations, then this delay and disruption protocol issued by the Society of Construction Law, which provides useful guidance on how to assess delays and quantum, etc., if the delay has resulted. So this is interesting phenomena which is again which has developed, and likewise International Court of Maritime and Air Arbitration has come out with its own rules, because these peculiar rules which are needed to take care of this. And we know about bilateral investment treaties again are different, to which I said that I will say in some more detail little later. But then ICSID we know, which is a body which normally settles these disputes through arbitration. Now, this is what I has been saying up to now has been about the globalization and its effects, etc. But another phenomena in last few years which has developed at international level is really what we call localized globalism or globalized localism. Now, and it is basically because of the developments which have been taking place in Asia Pacific, as Dr. Raju mentioned, that this century belongs to Asia. So what happens is that based on the experience of transplanting of arbitration in Asia Pacific, local culture and tradition continue to play a significant role in the process of legal globalization. On the one hand, global scripts are localized. So we have the principles which I have just now outlined, which are universal principles, which are taken, maybe developed in the West, they are localized. When domestic actors translate and conceptualize borrowed concepts in accordance with local norms, this is called local globalism. On the other hand, local ideas, practices, and institutions are globalized when they are projected onto the global stage, that is globalized localism. So this is very interesting phenomena which is taken place, and which is again churning insofar as various, because time doesn't permit to go into those aspects in detail, but this this is called globalization, that is the name given, and it is again bringing about many marketplace ideas on which a new jurisprudence is bound to come in few years, which we will witness. So that is another thing which we have to keep in mind when we talk of localized world, is that in some countries they say that we don't have to accept, and particularly in Asia some countries have taken the position that we don't have to accept whatever is given to us by the West, but we have to see whether it fits our conditions or not. And in this, where the world will take us, what would be the fate of, insofar as international arbitration is concerned, it is here to stay. Globalization is here to stay, no doubt about it. But as I said, that there may be some tweaking in respect of some of the principles which we may see in few years. Now, with this, I would just come to the second part of my discourse, where I said about the international investment arbitrations. This has it's a different category, a specialized category of its own. Bilateral investment treaties are entered into between the two countries, and where the investment is assured and the investor can sue the government itself or the republic of that country itself for if the investor thinks that he has lost his investment because of certain reasons attributed to or which may fall within the ambit of the bilateral investment treaty. Now, but what has happened, of course, as I said, ICSID or other such bodies which are doing this work have been doing commendable work. There's no doubt about it, let me say, in the first instance, and many cases are decided. But at the same time, as I mentioned, in last few years, there have been some discontentment as well. And it is due to certain reasons. One example, in Malaysia itself, which they faced that arbitration, although it was not BIT arbitration, where of course court settled, which our Honorable Deputy Law Minister also alluded to. And the only problem in there is that arbitrations are resolved, each dispute on ad hoc basis, with the Vienna Convention on the Law of Treaties. So therefore, there is an ad hoc mandate. And same problem, same kind of dispute, one arbitral tribunal will be deciding in one manner, other arbitral tribunal may be deciding in other manner. So therefore, this has created some kind of discontent where particularly third world countries have suffered the awards, huge awards against them, which may even affect their economies. Sometimes the award in billions of dollars, if it is against a small country like Sri Lanka or Bangladesh, it may have total ripple effect. So and if you, all of you know, few years ago, most of the countries, including Malaysia and India, had scrapped all these BITs because of this reason. And the feeling is that there is a partisan attitude sometimes. That may be right, that may be wrong, but that is the feeling. And therefore, it needs, for various reasons, now some kind of reforms are needed insofar as BIT is concerned. And here comes, let me enter the another concept or another part of ADR, allure of mediation. I'm talking of mediation now. That the discussion of mediation insofar as BIT is concerned is at two levels. Number one, that instead of arbitration, these disputes are better resolved through mediation itself, because these are between one investor, and on the other hand, it's a country which is a sovereign country, and sovereignty of the country is at stake sometimes. So therefore, mediation in that sense may become a better choice. Number two, to which I would come later, but at the stage of BIT itself, I may say, the combination of the two, which we call MEDAB. So that kind of, and ICSID has already provided that in its rules. So mediation is of course quite different from arbitration, and following can be said of its relative merits. Mediation can, as a rule, end a dispute more quickly and more inexpensively than arbitration. In mediation, the parties maintain control over their dispute, and unlike the imposed outcome of arbitration, a mediated result is the product of mutual assent and joint crafting. Mediations focus on interest instead of rights. Moreover, encourages the parties to design a bargain that is not circumscribed by the legal case of each or an arbitral tribunal's jurisdiction. Exchange of values that would not be within an arbitral tribunal's remedial powers thus can readily occur. In the process, the parties evade incoherent or divergent precedent, particularly, as I said, in BIT disputes, and avoid the risk of creating new, perhaps unhelpful precedent. Arguably, mediation also provides a broader opportunity to bring non-disputant stakeholders, this is very important, into the process. If they may not be a party in arbitration, you can't have a particular party which is not signatory to arbitration agreement, but in mediation you can involve them. Mediation is moreover exceedingly flexible. It can thus adopt to diverse legal cultures and can mesh with arbitration without either process being unduly disputed. So there are various advantages of mediation, and I would say here that in many ways mediation is the better form of access to justice. And because of this reason, the what has another trend, another phenomena which has come when we talk of ADR and new horizon in which the ADR is developing, that arbitration and mediation are in partnership in that sense. As I mentioned, MEDAB, ARMED, ARMED, ARB, etc. So MEDAB is where it refers to a consensual dispute resolution process in which a neutral first attempts to mediate the dispute, and if mediation is unsuccessful in fully resolving the dispute, switches to the role of arbitrator. And ARMED is just the opposite. Let me give you one example, and it's really happened, my personal example. There was one dispute between the two parties, and ICC was the seat of arbitration. This arbitration was initiated, other party filed suit, anti-suit injunction or anti-arbitration injunction, which was granted by Delhi High Court. Matter remained pending for few years, interim injunction was granted. After a few years, the suit was dismissed. So appeal was filed. In appeal, the matter was referred to me for mediation. I conducted the mediation proceedings. Because of lapse of few years, the complexion of dispute had changed. In the meantime, because so much development had, for paucity of time, I can't give the details. But what I'm trying to emphasize is, I could settle 80% of the dispute. 20% which remained was on the legal aspects, which the parties were not, they were taking their position. So what happened? One was that, okay, it goes back to the court because I have not been able to settle. But the parties agreed, a novel idea which came, and I persuaded also, that look, 80% you have where you have settled, please enter into settlement in respect of 80%. Why this 80% should go back to court? They agreed, the settlement agreement was signed, but at that stage the parties themselves said, because it was sent to me through mediation, that as far as 20% is concerned, we appoint you as the arbitrator because you have understood in the meantime. And within 10 days, I could give my award on that legal issue. And that finished. So this is a unique example of MEDAB. As far as ARMED is concerned, I tell you again, this is almost in all, laws relating to arbitration in countries, and even in India it is there, that even when the matter is referred for arbitration, an arbitral tribunal is constituted, it can always make an attempt to see if the dispute can be settled, where the word is conciliation. That is why it is called Arbitration and Conciliation Act. And in 4 or 5 cases, particularly construction matters, where I was appointed as arbitrator by the court, ad hoc arbitration, when I saw the dispute, I said it has all the elements of settlement, and I could achieve those settlements. So therefore, these are some of the things which are happening, and this is really becoming interesting. Now, when mediation is also coming close to arbitration, of course it is far behind at present, but then in a great measure, almost all countries are now supporting the mediation. Governments are also supporting, and there is a need, if the settlement takes place in international mediations, for enforcement. And that is why we know recent development was in 2018 Singapore Convention on Mediation, which was signed. And of course, not many countries have, so those who have been signatory have legislated. But as far as India is concerned, again, let me only inform you that Mediation Act, the draft, this bill has been introduced, and in the monsoon session last month only, the upper house, which we call Rajya Sabha, has already passed that mediation bill, and it is now pending before the House of Commons, which we call Lok Sabha. So these are some of the aspects which are emerging. For lack of time, I am not touching upon the other, but I have in my essay mentioned that how the artificial intelligence is going to play a major role insofar as ADR is concerned, and again, how the technology which not only, and which we saw in a great measure during COVID, that because of this technology, not only we had run online courts, the court hearings, etc., but more online arbitrations. And another phenomena because of this technology is now online dispute resolution is going on. And it has, in various countries now they have come out with that there are certain kinds of cases which are better decided online, and more particularly the cases which are consumers. You today online, you buy so many things from Amazon, you are buying eBay, etc., all these. And but if the product you get is not good, for such small things, for 5,000, 10,000 rupees or ringgits, you can't go to court. So it's better, they have now provided that, yeah, it can be settled online. So it's another area which is developing as ADR online, and it is going to catch up. In conclusion, I would say that there is a lot of churning which is happening. If you see what was the position of international arbitration or mediation 20 years ago, today it is totally different. On the one hand, as I said, its own international jurisprudence on arbitration is emerging, which is ever changing and is getting reformed day by day. On the other hand, ADR is coming, and how, this mediation is coming, and how the two are becoming partner, that is also, and I think you have mediation rules, but almost all such arbitral institutions today, they want, yes, we are giving an opportunity to the parties to mediate in the first instance if they can do so. And in many countries, again, I would give the example of India, we have Section 89 of the Code of Civil Procedure, where even the suit is filed, and it is before the court, the court can send that for mediation. Mediation also, arbitration also. And if mediation fails, it would come back, otherwise it would be settled, and then a decree is passed by the court itself for this. So these are some of the aspects which I thought that I would highlight insofar as this theme is concerned. And I wish you good luck. There are many very important and sessions where there's going to be intimate and hot discussions and thorough discussions on that. And my, I would say all the good wishes to the organizers. Thank you very much.
Thank you. Thank you, Justice, for your words. May we kindly request for you to remain on stage, please? Sorry. We'd like to invite Yang Berbahagia Professor Dr. Rahmat bin Mohammed to come up on stage and present a token of appreciation to our keynote speaker. Thank you, IB Professor. Thank you, Justice. With that, distinguished guests, ladies and gentlemen, we have come to the end of our keynote session. Without taking much more of your time, may I invite you all to join us for lunch at the dining area at the lower ground floor. There will be ushers to guide you at the entrance. And as a gentle reminder, we will be having our second session here at the auditorium at 1:30 p.m. Our team will reach out to you and will be most delighted to have you join us for the session. Enjoy your lunch, and we'll see you at 1:30 p.m. Thank you.